medical procedure and or treatment, and what your rights at common law, under statute, and under the Constitution are with respect to not being able to be forced to undergo any medical procedure or treatment without your expressed informed consent. Now, a medical procedure or treatment is anything that affects your medical health, whether physically or psychologically. So, generally speaking, the governments have been hiding behind the fig leaf that none of these measures are specifically mandatory, except that if you, quote, choose not to comply, you lose the right to travel, buy food, and any right to medical services. So they are de facto compulsory, depending on your situation and circumstances. Now, at common law, before the patriation of our Constitution, administering medical procedures without expressed, informed, explicit consent was considered an assault, and liability and damages ensued. So, if a doctor or surgeon administered medical procedures or treatment without expressed, informed consent, he or she was liable in damages. So you have a common law right and you have a statutory right. And expressed, informed, explicit consent means just that. Number one, you must be informed of the procedure and treatment before it is administered, including the possible side effects it may inflict. Two, you must express your consent orally and or in writing. And three, consent must be completely voluntary, asked of your free will, absent of any threats, compulsion, or deceit from the person seeking that consent. Under our law in Canada, this expressed informed consent cannot, and I repeat, cannot be, quote, implied, as fraudulently put forward by the WHO recently with respect to vaccinations at school, when it stated that consent may be implied. Quote, the World Health Organization said, an implied consent process by which parents are informed of imminent vaccination through social mobilization and communication, sometimes including letters directly addressed to the parents. Subsequently, the physical presence of the child or adolescent, with or without an accompanying parent at the vaccination session, is considered to imply consent. This is absolutely fraudulently bogus. It does not apply in Canada. In Canada, you do not have any doctrine of implied consent when it comes to medical procedure or treatment. The fact that government is mandating and purporting and wanting to roll out these mandatory procedures and treatments does not remove the obligation of obtaining expressed informed consent from each of us. In 1982, Canada patriated its Constitution. Part of that Constitution was the Canadian Charter of Rights and Freedoms. In the Charter, there are 5 rights that speak to this issue of medical procedure or treatment without consent. They are sections 2, 7, 8, 9, and 15. It's the rights in section 2A and B, conscience, religion, thought, and belief, that apply to whether or not you choose to have a medical procedure conducted on yourself or not. The Canadian appellate courts, including the Supreme Court of Canada, have determined that injecting any medical drug without expressed informed consent is unconstitutional. For example, the Ontario Court of Appeal, even in the context of violent psychiatric patients, determined that the injection of mind-altering drugs without the patient's consent is unconstitutional. It's our strong view that nothing different holds for vaccines. The Supreme Court of Canada has reiterated this right and principle many times over under the Charter since 1982. So, with respect to vaccines, mandatory vaccines without expressed informed consent are clearly unconstitutional, infringing the Charter as already determined under Section 7 of the Charter by Canadian appellate courts. Where there is a religious or conscientious objection to vaccines, particularly those containing fetal or animal tissue, There's a further violation of Section 2 of the Charter based on conscience, religion, and creed. Many people object to those type of medical tissue being injected into their body on conscientious and religious grounds. In addition, under Section 7 of the Charter, there are two Supreme Court of Canada decisions which bear and import the Nuremberg Code and the Helsinki Declaration. The first case is the case called Baker, on which I co-counseled with Mr. Roger Rowe in 1999, which established that when you're interpreting Canadian domestic law, it must be interpreted in accordance with applicable international treaty, whether or not we have domestically ratified that treaty. And subsequent to the Baker case, the Supreme Court of Canada decided a case called Hape, where the Supreme Court clearly ruled that any specific right contained in an international document or instrument is read as a minimal protection under Section 7 of the Charter. So it is therefore more than arguable and the case that the rights and protections contained in the Nuremberg Code and the Helsinki Declaration are protected under Section 7 of the Charter. Now, even if they were not, our Charter has already been interpreted to protect your right against forced medical treatment. The only exception in Canadian law to this clear holding and constitutional right, and it appears as an exception but it is not, is in the case of a minor child that faces an emergency situation where severe, gaugeable harm or death is imminent without medical intervention, and where parents refuse consent on religious grounds. There are several Supreme Court of Canada cases on this, and what the Supreme Court has done is drawn a balance between the religious views of the parents with the rights of the child. And in those cases, by way of court order usually, or legislation by the child services departments, they can override the wishes of the parents and actually apply medical treatment to save the child's life. The threat to harm or death has to be imminent. It has to be gaugeable, it has to be certain, it has to be clear. And so in those cases, while it may appear that there's no informed express consent to the medical treatment, that's a bit of a fallacy, because this exception is consistent with our constitutional framework in that children are not the property of their parents. Children have their own independent Section 7 and 15 Charter rights to life, liberty, and security of the person, and to equal protection under the law. Now, this is clearly a complex and controversial issue. However, it does not take away from the principle of the constitutional right to refuse medical procedure or treatment without expressed informed consent, where that person does not have the legal capacity to consent, such as a minor child. So now, when we talk about children, there's also a doctrine which refers to a mature minor, and that is a minor who's in the range of 13 to 16, who sometimes can express their own wishes. This, the Supreme Court of Canada case and these blood transfusion cases has said should not be exaggerated. The common law doctrine of mature minor cannot override the wishes of the parents with respect to consent outside the context of an emergency threat of harm or death. Secondly, legislation has also covered this. For instance, in Ontario, if you're 16 or over, you can make your own decision on vaccination or medical treatment, regardless of what your parents' view is. So, statutorily in Ontario, even though it's not the age of majority, for the purposes of consenting to health treatment, if you're 16 or over, you can give your own consent. In the same way that when you're 16 in Canada, you can possess your own independent passport without your parental consent. Now, very briefly, some of you have also said, well, what if they just pass legislation under Section 33 of the Charter, the so-called override provision, in which they can just override the Charter rights that I'm citing as being breached by these measures. And Section 33 of the Constitution Act allows them to override the rights contained in sections 2 to 15. However, this is also a bit of misunderstanding and limited understanding of our constitutional framework. Even if they overrid these, which would require full debate in the legislature, these same rights are some of these same rights are duplicated and recognized and were recognized as unwritten constitutional rights under our Constitution before the patriation of our Constitution in 1982. So these are rights, constitutional rights, recognized as pre-existing, and they exist both in our Charter and as unwritten constitutional rights with different contexts and analysis. So to give you an example, the right to an independent judiciary was recognized as an unwritten constitutional right long before our patriation, and has now been read in and duplicated under Section 7 of the Charter. So what is of importance is that these constitutional rights that were recognized prior to the Charter are not subject to Section 1 of the Charter, and they're not subject to a Section 33 override by the legislature under Section 33. And this is driven home by Section 26 of the Charter, which itself reads, quote, "The guarantee in this Charter of certain rights and freedoms shall not be construed as denying the existence of any other rights or freedoms that exist in Canada." So what Section 26 of the Charter says is that you cannot interpret the Charter rights so as to diminish pre-existing constitutional rights that existed before the Charter was enacted.